Hello, this is Karen White and I am presenting on intellectual property protection for the IDEA competition. So what is intellectual property? Intellectual property is property that is the result of creativity or creations of the mind and can be owned by an individual or a corporation or company. Just as a home can be owned or a car, intellectual property can be owned as well. Intellectual property protection are the laws that establish and maintain these ownership rights. These are legal entitlements to be the only one to gain from that intellectual property. You have the right to exclude others from gaining from the idea. In other words, you have the right to exclude others from making money off of your intellectual property. So let's take a look how intellectual property can add value to your company. We have a company A here that has your typical assets for a business: building, equipment and inventory, and customer and employee goodwill, and common law trademarks and trade secrets. But company B has gone above and beyond that and added registered trademarks and copyrights, patents, intellectual property assignments and non-competes for employees and contractors, formal trade secret protection, and form contracts with employees, suppliers, and customers, adding a whole nother level of assets for the company. In this presentation, I'm going to very quickly and briefly cover the four types of intellectual property protection: copyright, trademarks, trade secret, and patents. Starting with copyright, we often think of copyright as it relates to books, music, movies, and such. But computer software can also be copyrighted, and it can add value for businesses. There are many items related to businesses that can be copyrighted: websites, brochures, if you have instructions for how to use your product, or drawings that have value for your customers, those can all be copyrighted. And the copyright protects that work from being displayed, reproduced, or used by other people. One point of clarification, because I've had this question a few times over the years. The question was, if I have a drawing of my mechanical device and I copyright the drawing, is my mechanical device protected? And the answer is, it is not. The drawing of the mechanical device is protected, but somebody could go ahead and build the mechanical device and then they can use that. In that case, you would want to have a patent to protect your idea. Copyrights last for a very long time. For an individual, such as an author, it is the life of the author plus 70 years. For a corporation or business, it's 95 to 120 years. And copyright is extremely easy to use. You can simply put the word copyright, the C with the circle symbol, the year, your company name, and you can add something like all rights reserved. And the moment that you put that on the brochure, or the website, or the drawing or instructions, your product is protected under the copyright laws. It is as simple as that. The copyright does not need to be registered for protection, so it's protected the moment that you put that copyright symbol on it. If you were to pursue legal infringement, then you would need to have the copyright registered. Trademarks are another very valuable form of intellectual property protection that is very easy to use. I've shown some very common trademarks: the Coca-Cola, Nike, and a trademark is a word, name, symbol, or even a device that is used to identify the source of a good or service. So by trademarking, you prevent others from using very similar logos or names to confuse customers that they are actually buying your product when they are not. And Nike is a great example of a company that's done extremely well with trademark. Both the Nike name and their swoosh symbol logo are independently trademarked. So they've trademarked both separately because in their view, both provide high value to their company. Again, trademark is extremely easy to use. You can identify a trademark from the first day that you use a logo and so forth by adding the TM symbol to it. You're seeing it here with the Google. And at that point, you're protected under trademark laws. If you go through the process of getting the trademark federally registered, then you use the R with the circle symbol at that point in time. But you can start from day one with the TM symbol. So very easy to use and has very high value for your company. Trade secret is a very underutilized form of intellectual property protection. The most famous is the Coca-Cola formula, which was developed in 1886. Had the formula been patented at that time, it would have been public when the patent was awarded. And I talk about this more when I talk about patents. And the patent term would have expired by 1910. So as of 1910, other companies could have used the information in the patent to copy the Coca-Cola product. But they've kept it a very heavily guarded trade secret all these years. And trade secret is any information that derives independent economic value from not being generally known or readily gained. It's often chemical formulas, compilations, programs, devices, but it can also be business methods or techniques or processes. The Uniform Trade Secrets Act protects trade secrets if they've been disclosed or gained by improper means. From a business perspective, again, what you may want to look at protecting are customer lists, survey results, business methods, and processes. And what is looked at to determine if it was really a trade secret or not is the information known outside the business, the extent to which it is known to those inside the business, and the precautions taken to guard the secrecy of the information. So what you want to do if you have information that you want to have as a trade secret, you want to identify it by putting confidential property of company X, which you're seeing there in the red, on all the material. And you want to have company policies and procedures to keep it secret. So do any suppliers need to know the information? If not, make sure that your employees know not to disclose it to them. Who within your employees needs to know the information? It should be on strictly a need to know. If they don't need to know the information to do their job, then they shouldn't have access to it. And how well you protect it as well is looked at. Are the offices locked? Is the information left out on desks? Is it locked up in safes and so forth? And those are all factors that are looked at to determine if something was in fact a trade secret. Patents provide the inventor the right to exclude others from making, selling, offering to sell, or importing the invention in the United States. In exchange for full disclosure of your idea, so when you submit your patent application, you have to put in everything that you know or understand about your idea in the patent application. Full disclosure is absolutely required. And in exchange for doing that and putting that information into the public domain, which is what will happen when your patent is published, you essentially receive a monopoly for the term of the patent. So for the term of the patent, you are the only one who can gain financially from that idea in the United States. And that process, the whole idea of patents and so forth, leads to a better society as we build on one another's ideas as they get put out into the public domain. There are three types of patents: utility, design, and plant. And then there are types of utility patents: process, article of manufacture, machine, and composition of matter. The utility patent is the most common type of patent and what most people are thinking of when they are thinking of patenting an idea. An example of a design patent is if somebody had a unique carving or design for a headboard. You cannot patent a headboard because that's been in the public for centuries, but you can patent a unique design or carving of a headboard using a design patent. And you can patent anything under the sun created by man, but you cannot patent something found in nature. So even if you are the first to find a new species that wasn't known to man before, you cannot patent that. The patent terms vary by the type of patent that you have, and it can be very confusing, especially for a utility patent. The start of the term is when the patent was granted or allowed. So when you get the notice that your patent has been granted, that is the start of your patent term. The end of the term is 20 years from the patent filing date or your application filing date. And it typically takes almost 2 years for a patent application to go through the process to be allowed. So the patent term is always something less than 20 years and varies from patent to patent. So again, kind of confusing. The term of a design patent is 14 years. And what I'm talking about here is really just the U.S. Patent and Trademark Office. If you are interested in protection in Canada or countries in Europe or Asia, you have to go through foreign patent applications that must be filed separately. There are two basic types of patent applications, provisional and non-provisional, and then there are subtypes under non-provisional, which I won't go into any detail. A patent is allowed from a non-provisional patent application. When the America Invents Act was passed, the provisional patent became even more relevant to the patent world. At that time, the U.S. went from a first to invent filing system to a first to file filing system, copying the rest of the world. The provisional patent, because it doesn't have the claims and an oath or declaration, is generally a faster process to get an application filing date, but it is not examined. It's really just a placeholder, and it becomes abandoned after 1 year. So once you've filed that, it starts a 1-year clock, and in that 1 year you must convert it to a non-provisional, or you lose the opportunity to patent that idea. But during that year, you can be testing the market or trying to improve on your invention. So it can be a very handy part of the patent application process. The claims of a patent application really define the boundaries of the invention. They really put the box around the invention and distinguish it from other patents and such. And it's really the claims that are what are looked at in infringement cases and such, and it's the legalese of the patent application. What is the important part of the claims is the balancing act that you have to have between writing the claims so narrow that they're easy to design around, but also easy then to get the patent allowed, versus writing the claims broader so they're more difficult to design around, but also make it more difficult to be different than what's already been patented. And so you're really trying to balance those two and find that sweet spot where you're just broad enough that you'll get the patent allowed, but not too narrow that it's easy to design around. The owner of a patent must be a person or multiple people. It must be individuals. It cannot be a company or a corporation. The way that companies or corporations own patents is by being the assignee on the patent. So if I'm an engineer for 3M and I design the adhesive for Post-it notes, when the patent application is filed, I am listed as the inventor and the patent is assigned to the 3M Corporation. And at that point in time, 3M owns that patent. So this is how companies own intellectual property. At the point that an assignee is named on a patent application, or it can be added at any time during the patent term, they can exclude the inventor from any further proceedings with the patent process. So this is something to really understand, that you are in effect transferring ownership of that patent to the assignee. This is different than licensing your invention or idea. That is a contract, and what essentially you are doing as the person who owns the patent or idea is you are saying to the licensee that you will not sue them for infringement during the term of the contract, that they can use your idea to make money and so forth, and it's usually in exchange for royalties or some type of financial compensation. But you're giving them the right to practice the technology and saying that you will not sue them during that period of that contract. You are not transferring ownership of the patent. You retain ownership of the patent. So you want to be very careful how to appropriately use an assignee versus a license. Sometimes I'm asked who can file a patent application. The inventors can file a patent application with the USPTO. You can also hire a registered patent attorney or a patent agent to do so. What you can't do is use a buddy who maybe has multiple patents and experience with the application process. They cannot represent you to the U.S. Patent and Trademark Office. If you are considering patenting an idea or invention, one of the first steps that you want to do is really look at what has already been patented. And there are multiple websites that have very thorough patent searches that you can use with keywords and such types of searches. And I've listed some of these websites here. I often get questions about what it costs to file a patent application. I've listed the website here for patent filing fees with the U.S. Patent and Trademark Office, so you can go and look at those. And then I've also listed a website for a patent agent and the fees that he charges, which are pretty typical. But for a patent, a utility patent for a mechanical device, a typical patent is going to cost, between the fees and the patent agent or attorney fees, somewhere between $5,000 and $10,000. Some best practices to think about: even with the first to file, you still want to keep good records. You want to have an inventor's notebook, dated photos and receipts. You want to build prototypes of your idea. You want to avoid talking about the invention except with persons who have signed a confidentiality agreement or who understand that it is confidential and not to be shared. As I mentioned, you want to search to really see what is possibly patentable. And you want to continually work and think about, especially with the cost being between $5,000 and $10,000, who is going to pay me? Who is going to buy this product? Where is my market? Who might want to license it and pay me that way? You want to think about how you're going to get a return on that investment. And if you do decide to work with an attorney or agent, keep asking them and yourself, what can you do to keep costs down? So what work can you bring to them to keep their billing hours down and save you money? So in closing, I just want to quickly compare and contrast the types of intellectual property we've reviewed. Patents protect the knowledge behind how to make an invention, and the patents expire within 20 years. Copyrights protect the work, and they expire within 70+ years. Trademarks protect the name or image, and trademarks never expire. And trade secrets protect anything secret, and they last until that knowledge becomes public. I hope you have found this very quick review of intellectual property protection helpful, and thank you.